public defender is not, he's not assistance of counsel.
No, it's not assistance of counsel, but because of that, not knowing what's going on, the person accepted the guilty plea bargain thing. Okay?
Inadequate assistance of counsel. But in fact, Ferretta, which is a California case, he was found guilty. He fired, I think it's somewhere between 5 and 6 attorneys before the judge, a guy walked in the door and he says, that attorney right there is your attorney and you're taking him right now. Enough of this. He is found guilty. Spent 2 years in prison. He appealed to the Appeals Court of California. He lost. He went to the Supreme Court of California and lost. He went to the United States District Court of Appeals and won. Court of Appeals, U.S. District Court of Appeals.
Okay, I've never heard of that.
They're the appeals court. It's the district court for the district. The Ninth Circuit Court, 10th Circuit, 5th Circuit. Okay, so what they did is then the state, thinking it's right and all that, appealed it to the Supreme Court. The Supreme Court heard it. Ruled in favor of the guy. They immediately released him from prison. The reason was, Ferretta, the reason is because of the fact that he said that he wanted to be his own attorney and they denied him that because it was a criminal proceedings. And because the attorney lost, he won.
Oh, I see.
Because the attorney was bad, because he lost. If the attorney knew how to defend him, he would have won.
How do you spell it?
Don't have a clue. It's in the book information.
Okay, it's in the book.
It's on the CD.
Okay.
That's going to be for sale, but I mean it's it's also in the book. What?
Well, is there a waiting period before you can file a civil rights lawsuit against a judge?
No, the minute they violate your rights is the minute you file the suit.
But you can do it like a year later?
You can do it 7 years later. Civil rights are the only one you got 7 years. Each act, Fair Credit Reporting Act, Fair Credit Billing Act, Fair Debt Collection Practices Act, all have a 1 year time limit.
1 year?
1 year. So if you're smart, you call up the guy again when you realize that he made a mistake. You call him up and have him send you one more letter. They send you a letter. Now they just tried to collect it again. So then now you can do the dispute. And now you moved your statute of limitations forward so you can sue them. Because it's also from the last predicated act, which is the last letter that you received from them. But, so I mean, it's fun. To me, this is fun. I mean, I don't know. Somebody serves me a piece of paper, I look at it and I laugh and I say, all right, thanks. Somebody else hands me, oh, cool, can I look at that? All right. They didn't do that, didn't do this, didn't do that. Here, you want to go get them. You know, they ask for my opinion. Here, this isn't my opinion, but this is what I'd do. Here, let me see. I'll do some research on that. Here you go. Have fun.
That's already.
I mean, it's amazing what they don't do and what people are supposed to do. But nobody, 99% of the people never go from the district court or the county court and go to the next court.
If you're already in court, say it's a bank against an individual on a commercial loan, business loan,
Take it to federal.
and they're already in court, you can still remove it?
You remove it for diversity of citizenship. You ask for a motion to dismiss for diversity of
What if the
citizenship.
bank's in the same state?
It's not.
California bank?
If
California.
If it's a California bank, it's not listed in California.
Okay.
National Association banks
Yeah.
are the ones that usually sue for the bank.
Small private bank.
If it's a small private bank,
Not private, but small,
it's still, their charter is in Washington, D.C. So their parent company must be in Washington, D.C. If the parent company is in Washington, D.C. and you're in the state of Texas or in the state of California, you can sue them for diversity of citizenship. You can remove the case from the court that it's in to federal just on banking law. Because UCC is not banking law. UCC isn't even law. If I was anybody, I'd never quote any UCC law. Because within the UCC law, it contradicts itself somewhere down the line that what you just said is wrong. And you'll hear this, if you send a letter to them, they'll say, well, that part doesn't apply. Why do they say that doesn't part apply? Because over here, this part applies. They asked you this set over here. It does not mean what it means over here in the code. So it contradicts itself as much as the IRS code does.
In other words, there's a lot of wiggle room in there, but every time they want to change.
Well, whatever they want to change positions, they can find a part in the UCC that applies. There's only 3 sections that actually have only one interpretation. It's a UCC 1, UCC 3, and UCC 11. Those are the only 3 that have never changed what they mean. Okay. The only one under UCC law, the only company, or I should say the only entity, that can file a UCC lien against a property is an equity corporation or a corporation. Anybody else that tries to do it, it's illegal.
You can't file a UCC form yourself?
No, unless it is against a property. That was kind of, hey, that is a whiteboard. Now I'm going to take a 10-minute break so everybody can run to the bathroom. Let's see if I can get this to do what I want it to do. So we already talked about this stuff. So I'm going to go to, you can't read that fast? I can. I can read that fast, I just can't say it. I'm just trying to speed it past the section that we were in.
Do you know what page you want to do?
No. Because it got reformatted and it changed all the page numbers.
No, it didn't.
Whoops, now it's going all over the place. Click.
Page number is the same as the one you had yesterday.
I know. That's not what I had when I got here.
Oh.
It was changed while I was coming here.
Ah.
I did not edit it. Because if I would have edited it, there would have been more dyslexic spelling. Let's go up. Let's see. Click, and then this button should go up, right? Right? Up. That's down. Where's up? Okay, this isn't going to work. Just a second. Got pointed at this is. It's this new technology. Come on, get down there. What do you mean unable? Oh, that's why you're unable. All right, anybody heard of the credit card stop payment before?
Yes.
No.
How many people have? Raise your hands. Oh, look at that. A credit card stop payment is where you charge something on a credit card, you call the credit card company and demand a charge back. Credit card company credits your credit card the amount that you charged. Okay. If you ask them to do that and they don't, you get $11,000. If you ask for a demand charge back for a billing error, they have to charge back the merchant the amount of money. It's a demand chargeback. But everybody knows how shady the travel industry is.
Right.
I've been interviewing a gentleman.
Fast line.
No, I've been interviewing another gentleman. What he does, he has a travel agency. And his name will be anonymous because he's giving me information that the travel industry uses that they'd probably kill him if somebody told him this. But what they do is they will, let's say you go on a trip or somebody buys a trip and then they cancel the trip. They demand a chargeback. Demand.
Okay, yeah.
So the account pulls it from their account, puts it into the account, and then now that merchant is out the account. Well, what some people are doing are going on the trips, taking the trips, enjoying the trips, and then charging back the account, and they have to, the Visa demands that the merchant charge it back. So this guy had so many of these happen to him this way, when he knew that the people went on the trip, that he got a little upset. So he formed a German corporation, and the German corporation got a merchant account. And then he sent a letter to all the people that he knew that took the trip that charged it back on their credit cards. And he said, we're doing a demand draft charge on your credit card. You have 10 days to respond. So they sent it to Germany, got the payments. His other corporation got the money, and then they charged back the merchant account, but the corporation in Germany didn't pay Visa. Did not pay Visa the chargebacks. So Visa discontinued their merchant account. But the guy still ended up with his money that he got ripped off from the other people. But that's what he did. He got so frustrated because all these people were doing this. I didn't know that too many people in the travel industry were doing this, but they are. A demand chargeback is the best weapon against internet and television purchasing. It's where you purchase something on the internet, you get it in the mail,
And it's not what you thought.
and you go like, wait a minute, this is a $2.50 toy. It is not what they presented it to be. So you do a billing error and chargeback demand. That institutes the credit card stop payment part.
Pardon me.
Now this should be working good now. Let's see. Let's see how good I am. Okay, I'm not. That's the wrong, there we go. Now I'm going to go to the letter, which is this goes all through all of the anything you ever wanted to know about the chargeback law, about fair credit billing. And this is this is a nice letter. They basically ask for a chargeback demand for the amount paid by Sam's Garage. Because in LA, Sam's Garage said that they fixed the transmission, put a brand new transmission in, fixed it all up. They went home, had a mechanic look at it, and all the guy did was add tranny fluid to the transmission. So they charged back Sam's Garage. If I were to do any engine repairs on any vehicle, I'd use a Visa. Okay? Because I hate to say it, but there are good mechanics. I know when he's really good, he can make anything work. He does this to the motor and it runs. He's in tune with it. But there are people out there that are shady. Usually some garages are that way. Transmission companies, really. And that would be your number one defense. So I'd always pay with a credit card if you're getting your car fixed. That way you always have your remedy to get it back. If you write a letter and you're going through 6 months of negotiations with the original creditor saying, look, you guys didn't put the transmission in, you're sending them letters, a good faith stop payment means that you sent a letter and you tried to do the dispute with the original creditor. You did the dispute with them. You told them you weren't satisfied. They refused to give you back your money. So therefore now you can do billing error, chargeback demand, and they credit it back to your credit card. If the bank refuses to do it, the bank owes you $11,000 because that's what the violation is if they don't do it.
How do you implement that?
You sue them under the Fair Credit Billing Act
Federal court?
in federal court. Yeah.
Would that be true with a debit card also?
No. A debit card, well, if the debit card has a Visa logo, it'll be credited back. or MasterCard. MasterCard and Visa are the same company.
So if it has the logo, it will be charged back.
Right, if it was charged. If it was debited, then there's a different process that you have to go through. And it's called the,
The PIN number is debited, but if it's used as a credit card, it can be charged back.
correct.
Is that correct?
Are there parameters surrounding guidelines, that say, under these circumstances, they have to return it, or is it a blanket thing? Or
It's a blanket thing. When you ask for a demand chargeback and billing error, they have to. They cannot quorum one way or the other. The minute that you ask that, Visa goes in, knocks on their door, give us the money to the merchant.
Okay.
Is it only for Visa?
It's also a MasterCard, any credit card,
Any credit?
any credit card. So
Any credit card or like a Home Depot or a Sears or Penny's or
any credit card. Any credit card that bills as a billing, has a billing function. They send you a bill. Because the contract, on the Fair Credit Billing Act, they have to provide all of the information, your original contract you signed, the terms of the agreement. They have 30 days to produce that document. If they don't produce it in 30 days, they violate the Fair Credit Billing Act. Okay?
Oh, no.
They have 30 days.
The credit card company?
Yep, they have, the vendor has 30 days to pay it back. The bank has 30 days to do it. And if you call them, the funny part is if you call them and you ask them to do it and they refuse to do it, now they owe you $11,000. They don't have 30 days. Why? Because they can walk up to the merchant and say, give us the money. Or you don't get Visa or MasterCard anymore. You want to rip off people, Visas and MasterCards, give us the money back. If you're not going to give us the money back, you cannot no longer have the merchant account. You can no longer use Visa or MasterCard. That's Visa's and MasterCard's power to get the money from the merchant. But the merchant might try to sue you for losing the money from Visa. But if the bank tries to put up a little thing like, oh, no, you can't do that, they did it. It's not up to the bank's determination whether they did it or not. So, now what's really funny is if you order something, and then they give you an 800 number to do the dispute, to talk to the person,
Right.
and you call the 800 number and there's no line, it's disconnected. That's an immediate notice that, hey, these guys were wrong. I turn around, walk back in the bank and said, look, the 800 number you just gave me doesn't work. It's disconnected. Oh, we'll credit that right now. Yeah. I mean, they don't have a choice. But see, the whole thing about the Fair Credit Billing Act is if you ask for validation under any other act and they don't provide you with the contract, they violated the Fair Credit Billing Act. So you might as well add the Fair Credit Billing Act, Fair Debt Collection Practices Act, and Fair Credit Reporting Act all into one letter asking for validation under all three acts. Because then you hit all three on the head.
Wait, billing,
Fair Credit Billing, Fair Credit Reporting,
reporting.
and Fair Debt Collection Practices Act.